The jury went home, but the real fight in Musk versus OpenAI did not stop. And honestly, this may be the part of the trial people are not paying enough attention to. Because while everyone is focused on Elon Musk's testimony, Sam Altman, OpenAI, Microsoft, and all the tech drama, the judge is doing something extremely important. She is narrowing the case. And as discussed in my prior videos, that may matter more than the most viral moment from the witness stand. I'm Lisette Eusebio. I'm an attorney and tech founder, and I'm following Musk versus OpenAI because this case is not just billionaire drama. This case is about AI governance and the mission language. And it is about what happens when a company says it is building for humanity, but later builds a structure that looks very different. So if you're a founder, builder, investor, or you're just trying to understand what is happening in AI law, please support us by subscribing to this channel. I'm breaking this case down in plain English as it unfolds. Now, let's talk about what happened in this case so far. Elon Musk's testimony has now wrapped after 3 days on the stand. And according to reporting from the courtroom, OpenAI's lawyers used cross-examination to push a very specific story. Their story is basically this. Elon was not blindsided. OpenAI's lawyers questioned him about emails, notes, term sheets, and earlier discussions about restructuring OpenAI. And that matters because Musk's side is saying OpenAI betrayed its original nonprofit mission, but OpenAI is trying to say something very different. They're saying Elon knew, Elon wanted control, Elon left, and now Elon has a competing AI company. That is the defense narrative, and that is a very jury-friendly story. Because if you are sitting there as a juror and you hear, wait a second, you knew about this, you wanted control, you left, and now you're suing your competitor, that is the kind of story that can stick. But here's where the case gets more interesting. Musk's position does not appear to be as simple as OpenAI could never make money. Based on reporting, his argument seems more nuanced than that. It sounds more like OpenAI could have a for-profit structure, but the for-profit side was supposed to remain controlled by the nonprofit mission. In other words, the issue is not just profit. The issue is who was in control. Was the nonprofit still driving the mission, or did the for-profit structure start driving the nonprofit? That is what people mean when they say the tail is wagging the dog. And yes, that sounds very dry, but stay with me because this is the whole case. Once you frame it that way, this is no longer just a story about whether Elon Musk feels betrayed. Now we are talking about governing documents. We are talking about charitable purpose. We are talking about whether assets or benefits were used in a way that matched the mission OpenAI was originally built around. And that brings me back to the point I made in the last video. Musk dropped the fraud claims before trial. That matters. Fraud is dramatic, it is emotional, and it lets you tell a story about deception. But fraud is gone. What is left are equitable claims, including breach of charitable trust and unjust enrichment. And those claims are different. They are much more judge-centered. Yes, there is still a jury. But if the jury is advisory, then the jury is not the final boss here. The judge is. The jury can listen. The jury can give its view, but the judge ultimately controls the legal analysis and the remedy. And now we are seeing why that matters. According to multiple reports, Judge Yvonne Gonzalez-Rogers has been cutting off broader testimony about AI, extinction, Terminator scenarios, and doomsday-style arguments, and that is a big deal. Because Musk may want to tell the biggest possible story. OpenAI betrayed humanity. OpenAI stole a charity. OpenAI became the thing it promised not to become. That story may work in the court of public opinion, but in the court, not so much. The judge is basically saying we are not trying the robot apocalypse today. We are trying the legal claims in this case, and that is a very different thing, and this is where trial strategy matters. In a regular jury trial, inflammatory testimony can be dangerous. Even if the judge gives a curative instruction and tells the jury not to consider something, the problem is obvious. They already heard it. You cannot make people unhear something. Any trial attorney knows this. That is why lawyers fight so hard about what comes into evidence in the first place. Attorneys often ask for mistrials if that happens. But here the dynamic is different. If the case is equitable and the jury is advisory, the judge has more control over the frame. The judge can hear something, recognize that it is outside the scope, and bring the case right back to the legally relevant issues. That is exactly why this matters. The big courtroom moments are interesting. The cross-examinations are entertaining, and the emails and notes are the receipts. Then you hear a lot of commentaries about who won, but the real question is not who had the better soundbite. The real question is, what do the governing documents say? What was the mission, and was that mission legally violated? That is a much narrower question, and that is exactly why the judge's role is so important. Now let's talk about Jared Birchall. Birchall manages Musk's family office, and his testimony matters because he helps establish how Musk's early support for OpenAI was categorized. Reports say Birchall testified about Musk's financial contributions, including donations and rent payments for OpenAI's early office space. Why is that relevant? Because Musk's side is not trying to frame this as a normal investment dispute. They are trying to frame it as charitable support for a nonprofit mission. That is the whole point. The argument is not just, I gave money and now I regret it. That's how OpenAI may want to frame it. Elon Musk's argument is more like, I gave money, resources, and support for a specific public benefit purpose. And if those resources were later used to create private enrichment or move away from that mission, then the court should step in. That is why the paper trail and the donations matter. The rent payments also matter. And most importantly, the governing document is the most relevant evidence. Because if this case is about breach of charitable trust and unjust enrichment, the judge is not just asking who seems more sympathetic. The judge is asking whether a legal obligation existed. Then the judge has to ask whether that obligation was breached. And if it was breached, the judge has to decide what remedy is actually available. That is the chess match, not the drama, not a potential missed IPO opportunity, and Elon Musk's AI exterminator framing. So when people say, oh, Elon got grilled on cross-examination, yes, that matters. But what matters even more is whether those facts are legally relevant to the remaining claims. Because if fraud is out, some of the emotional storytelling may not matter as much as people think. And if this case turns on equitable remedies, then the judge is not just watching the testimony, the judge is controlling what this case is allowed to become. That is the part I'm watching. Because this trial is not just about whether OpenAI made money, it is about whether OpenAI's mission structure, money, and control stayed aligned. And for founders, this is the takeaway. Do not treat mission language like decoration. If your company says AI for humanity, public benefit, or responsible AI, you need to understand that those words can matter later. They can show up in lawsuits, they can show up in discovery, and one day, someone may read your own mission statement back to you in court. That is not just an OpenAI problem, that is a founder problem. So if your public messaging says one thing, but your corporate structure says something else, you may be creating future legal risk. And in AI, that risk is even bigger because companies are using massive language around safety, humanity, alignment, and public benefit. So the lesson is simple. If the mission matters, build it into the structure. If the structure changes, document why. And if you are promising the public one thing while building incentives in a different direction, do not be surprised when that becomes Exhibit A. So yes, everyone is watching Elon Musk, but I am watching the judge because right now the judge is cutting off the big dramatic story and narrowing this case back to the legal one. And in this case, controlling the frame may control the outcome. I'll keep covering Musk versus OpenAI as the trial continues. Follow this channel for plain English legal breakdowns on AI litigation, tech law, founder risk, and the legal fight shaping the future of artificial intelligence. Because this case is not just about OpenAI, it is about what happens when mission, money, control, and AI all collide in court.